I'm Carl Conrad and welcome to the weekly edition of Australian Immigration News. This program is brought to you by Australian Immigration Law Services, the company I founded nearly 25 years ago right here in Sydney. Many changes this week for 482 and 457 visa holders. Also huge news about the ending of the COVID-19 concession period, which has multiple effects on a number of visas. At last, the regulations arrived yesterday that many 482 and 457 visa holders have been waiting patiently for. Remember, back in September 2022, the government announced that by the end of 2023, most temporary skills-sponsored workers would have a pathway to permanent residency. These new amendments that take effect from midnight tonight, that is Saturday the 25th of November, are the first step to provide an equitable process for permanent residency for temporary skilled workers. The next stage will come when the Migration Review is publicly released. The new regulations expand access to the Temporary Residence Transition Stream, known as the TRT stream, in the subclass 186 Employer Nomination Scheme visa. The changes also apply to the TRT stream of the subclass 187 Regional Sponsored Migration Scheme visa. The four key changes made are as follows. Number 1. The TRT opens to all streams. The regulations expand access to the TRT streams of the subclass 186 and 187 visas to cover all holders of subclass 482 and subclass 457 visas, regardless of the stream in which their visa is held. Number 2. Reducing the time to wait. The regulations reduce the length of the eligibility period that is required for approval of a nomination in the TRT stream. The amended provisions require that the main applicant worked while holding a subclass 482 visa, a subclass 457 visa, or a bridging visa associated with an application for a subclass 482 or 457 visa for 2 out of the 3 years immediately before the nomination application is made. Previously, the requirement was 3 years out of 4. Number 3. Which occupations? The regulations remove the requirement for the occupation identified in the nomination to be specified in any particular list. However, of course, you must be nominated in the same occupation as your 482 and 457 visa was approved for. However, the nomination regulations still require an occupation to be listed in ANZCO. The reason why I mention this is because there are a number of occupations sponsored in labour agreements which do not actually have a ANZCO code. If this is you, you can still be sponsored for the 186 visa PR via the labour agreement stream. Number 4. Multiple short stream visas. The new regulations remove the limit on the number of subclass 482 visa applications in the short-term stream that can be made in Australia. The requirement that an applicant must be offshore for their third or subsequent 482 visa has now been repealed. The Immigration Department themselves, in their explanatory statement, said, "In light of that change, there is no longer any reason for preventing making of multiple applications for the subclass 482 visa in the short-term stream in Australia." Now, our opinion of all this. Okay, these changes sound very rosy, and it's true, they are a great advancement to fairness between those who hold the 482 visas in the short-term stream and the medium to long-term stream. However, there is a significant flaw in actually what they haven't done, for the government has failed to amend the 482 regulations in the short-term stream, which contains the genuine temporary entrant test. 482 visa applicants in the long-term stream do not have to meet a GTE requirement. It is all very well now to say that 482 visa holders in the short-term streams can make multiple applications, but if the Immigration Department has power to apply the GTE requirement on visa applicants, then there is absolutely no certainty for the visa applicant or the employer who is spending big money to sponsor them that their visas will be granted. Keeping the GTE requirement in place is a major mistake if the government is saying they want to be fair to the short-term stream 482 visa holders. Yesterday came the major announcement that the COVID concession period will end on midnight tonight, the 25th of November. From tomorrow, the COVID concession period is now meaning as starting on the 1st of February 2020 and ending on the 25th of November 2023. A number of visas were given concessions based upon the events during the COVID-19 pandemic, and these will now cease. These concessions were brought in to assist people affected by the travel restrictions from February 2020 due to the pandemic, which made it difficult for them to meet visa requirements. Concessions were also established with the recognition that for many, the forced lockdowns in Australia affected people's ability to earn incomes and even to gain valuable employment periods. The impacted visa programs that utilize the initial concession period are the following. The temporary graduate visa. From the 25th of November, all applications for any stream of the temporary graduate visa program must be lodged in Australia. However, subsequent entrant applications can be lodged in or outside of Australia. The ability to grant 485 visas to applicants who are either in or outside of Australia will continue. Employer-sponsored visas. The following COVID-19 concessions will become redundant and will end. Periods of reduced work due to COVID-19 will not count towards meeting the work experience requirements for new ENS and RSMS applications in the TRT stream. The COVID-19 concession to the age exemption for high-income earning applicants will not apply for new ENS RSMS visa applications. However, the age exemption for Legacy 457 workers in Australia for 12 months during the pandemic from 1st of February 2020 to 14th of December 2021 will apply for ENS applications lodged before 1st of July 2024. The Skilled Regional Visa Subclass 887. The temporary concessions available to holders of eligible skilled provisional visas to apply for the 887 visa are set around the COVID-19 concession period. The concessions allowed subclass 887 visa applicants to lodge from in or outside of Australia during the concession period and to access shorter periods of employment and regional residence requirements. Applicants can only access the employment requirement concession if they meet the following: held a eligible skilled provisional visa during the concession period and make a valid applications up until Monday the 26th of February 2024. The ending of the concession period will end any other concessions for the subclass 887 visa. This means that after today, eligible skilled provisional visa holders applying for the subclass 887 must be in Australia but not in immigration clearance when applying. Family visas. The COVID-19 concessions removed restrictions on the location at the time the visa grant requirement for certain family visa program visa applicants. Applicants for certain partner and child visas who applied before the 26th of November 2023 and who were in Australia at any time during the concession period will continue to be eligible to be granted a visa in Australia after the end of the concession period. The COVID-19 concession arrangements will not apply to partner and child applicants who were not in Australia at any time during the COVID-19 concession period. The COVID-19 concessions for certain parent visa applicants only applied during the COVID-19 concession period from the 1st of February 2020 to the 25th of November 2023. Business Innovation and Investment Program visas. COVID-19 concessions were put in place for the Business Innovation and Investment Program, the BIIP, under the following arrangements. The Provisional Subclass 188 visa, the Business Innovation Extension stream, and the Permanent Subclass 888 visa under all streams. BIIP applicants who are eligible to exercise COVID-19 concessions to make a valid application can do so before the end of Monday the 26th of February 2024. And now it's time for our viewers' comment of the week. Philippe writes in and asks, first of all, thank you for your updates every week. So the question is 482 or 494 in regional areas. I think the 494 is less competitive in terms of years and requisites than 482. Philippe, thanks for your comment. The benefit of the 494 visa is that you don't need to rely on a sponsor for the second stage to get PR, as you will use the 191 visa pathway. However, with the 482 visa, the employer can offer PR after 2 years. But then if the 186 visa takes a year to process compared to the 191 visa, which is now very fast, then both pathways are not so different as far as timeline goes. Now, in relation to the requirements of both visas, the 482 visa is by far much easier to apply for. A very busy week of changes, but stay tuned, for in the next couple of months, we are sure there will be many more ahead. Next week, I will be on holiday, but I will try and have a video ready to be released next weekend that is not directly related to immigration news. However, if something big happens, then I'll just have to film it on my GoPro on the fly. Hopefully, I'll have a week to relax and then I'll be back in action once again. If you need help, then the whole office is still there to take care of your calls and make appointments with. As always, take care out there and I'll see you next time after my break. So, bye for now.